Children, Consent, Capacity and Competence. I'm Dr. Krisha Patel and I'm the Mental Health Lead for the company. This is part 4 of this webinar series and this is the final part. In this session, we're going to go through what makes consent valid and also go through 3 separate scenarios which will help us to consolidate our knowledge about Gillick Competency and the Mental Capacity Act. So let's start by talking about consent. Consent is only valid if it is given voluntarily, so that means it needs to be free from any undue pressure or free from duress. It needs to be given with a client who is adequately informed, so adequate information needs to be provided before the client can consent. So if we're talking about a surgical procedure, the client must be informed about the benefits of the procedure, the risks of the procedure, what the procedure actually involves, etc. And if we're talking about a forensic medical examination, the client needs to be informed what exactly a forensic medical examination involves. They need to be informed that this could be used in court as medico-legal evidence, and they need to be informed what exactly is going to be completed, so swabs for DNA, for example. And finally, the client must have capacity. So of course, we'll talk about capacity if the person is 16 or over, as defined by the Mental Capacity Act, or competence. So competence is the term we use for people under 16. And of course, we're referring to the case law that is Gillick competence here. So let's start with our first scenario. And again, this is an interactive session. So I would like you to read the scenario, then pause the video and write down your thoughts. And if you are working in small groups, discuss this scenario amongst yourselves. So scenario 1. The 12-year-old girl has disclosed historic sexual abuse and the alleged perpetrator is her father. Her father is no longer at the home address. The child has been safeguarded and social care have removed the father from the household. The child, who is 12, has been told about the SARC medical examination, and she's happy to go ahead with this. And we're talking about a historic disclosure, so there's no forensic swabs or acute time frame that needs to be worked to. So we're just talking about a historic disclosure of sexual abuse and a holistic SARC medical. So she's happy to go ahead with the SARC medical after it's all been explained to her. So she attends with her mother. And when going over the consent form, the doctor explains everything to the mother, and the mother does not give consent for the examination to go ahead. So the child is giving consent, but the mother refuses to give consent for this examination to go ahead. And because there is a disagreement, it's decided that the examination does not take place on that day. So pause the video and write down, what do you need to consider in this case? What factors are you going to consider? I'd start with the age of the child. The child is 12, so of course we're going to have to use the framework that is Gillick competency. So the first thing we need to do is actually assess ourselves if she is Gillick competent or not. So we need to assess with our criteria, make sure we've explained what the SARC medical examination involves, check if she has understood the information, getting her to repeat it back, for example, explaining the reasons for the medical examination, the consequences of not having the examination, and making sure she does fully understand what it is that is involved with this. So in this case, the child is 12 and she's quite mature for her age, and she is assessed as being Gillick competent to make her own decision. Then we need to think about the intervention that we're talking about. So is the SARC medical considered in the best interests of the child? As a healthcare professional, we only do things that are considered in the best interests of the child. So in this case, it is a holistic medical. We are assessing for other medical needs as well. So it's decided that a SARC medical is in the best interests of the child. We should also explore why the mother does not want the SARC medical to go ahead. And in this case, it's obviously a complicated familial issue. So the perpetrator, or the alleged perpetrator, is her husband. And for many reasons, including stigma, she may not want police and social services involved, and she may not want anyone else to know. However, what we really need to think about is making sure we are acting lawfully. So the child, who is 12, has been assessed as being quite mature and developed for her age, and she's assessed as being Gillick competent. So in this scenario, if the Gillick competent child consents to the intervention, which you as the healthcare practitioner have assessed as being in the best interests of the child, can the SARC medical go ahead with just the child's consent? And of course, the answer is yes. So moving on to scenario 2. This time we have a 16-year-old female with severe learning disability, and she lives in a care home requiring round-the-clock care. It's highly suspected that she's a victim of sexual assault. She's been found in quite suspicious circumstances by her carer. She's been unclothed and there's a male in the room. It is suspected that a sexual offence has occurred. So the police are informed, and the police have done an initial investigation. So the police officer then calls you and they ask you to do a forensic medical examination to gather the forensic evidence as part of their investigation. So what do you do in this case? Again, pause the video and discuss this with your colleagues or write down your own thoughts. So let's work through this scenario. So the child is 16, which means the legal framework we're going to use is either the Mental Capacity Act or parental responsibility. And we know that parents have rights over their child up until the age of 18, which is when the child becomes an adult. And you must assess capacity yourself. So you cannot leave that to the police officer to assess. Of course, you can take their views into account, but if you're going to consider doing an intervention, then you need to be the person who assesses that capacity yourself. So you use the criteria under the Mental Capacity Act. So can the client weigh information, retain information, understand information, and communicate their decision? If they can do all 4 of those, they have mental capacity, and they are presumed to have capacity unless there is some reason why you suspect that they don't have capacity. So in this case, you have to assess this yourself. And if you feel the client does not have capacity, you must document why, because there is a legal presumption that the child has capacity at the age of 16. So we already know the child has a severe learning disability. Of course, learning disability is on a spectrum. So if somebody has mild learning disability, they may be able to consent to some things. If someone has severe learning disability, they are probably not able to consent to a forensic medical examination. But of course, you assess this yourself and write down your rationale. So you can write something along the lines of, due to severe learning disability, the child is unable to weigh information, retain information long enough to make a decision, or communicate their decision and understand information. So in this case, the parents are allowed to consent on behalf of the child up until the age of 18, if the child is not able to consent themselves. And if there are no parents involved, parental responsibility may have been granted to the local authority or somebody else, or the courts are also allowed to make decisions for children up to the age of 18. So of course, we have to make sure a forensic medical examination is in the best interests of the child. And if we are suspecting sexual assault, and in this case, the suspicion is high from the circumstances and from what the information of the witnesses have given you, and from the police officer. So if there's a high index of suspicion a sexual assault has occurred, then it's probably in the best interest of the child to have a forensic medical examination. And of course, you're only going to do what the child allows you to do. And in this case, when we're talking about a forensic medical examination, we're not talking about something that's time critical or life-saving, like life-saving surgery or a blood transfusion. We're talking about a forensic medical examination. So thankfully, we have time to consider what we need to do. And it's going to be in the best interest of everyone to make attempts to get a parent or someone with parental responsibility to provide consent for that forensic medical examination to go ahead. And that is better then using the best interests principle under the Mental Capacity Act, which said if somebody lacks capacity, you can proceed if it is considered in the best interests of that person. But in this case, of course, if we can get consent from someone and we can get the consent from the parent or anyone else with the parental responsibility, then we should. So this is the final scenario, and this scenario is pretty much exactly the same as the scenario in scenario 2. The only thing that has changed is the age of the person. So in scenario 2, we talked about a 16-year-old child, and in this scenario, we talk about an 18-year-old female adult. So we're no longer thinking about children, because when somebody turns 18, they become an adult. But I wanted to talk about this scenario so we do make sure we fully understand the Mental Capacity Act principles. So everything else is the same. We've got an 18-year-old female adult with severe learning disability who lives in the care home. It's highly suspected from witness accounts that she's been a victim of sexual assault, and the police officer has gone out to the care home, taken the witness accounts, done an initial investigation, and highly suspects a sexual assault has occurred and asks you to do a forensic medical examination. What do you do in this situation? Again, pause the video and write down your thoughts or discuss this with your colleagues. So these are the steps I would take when thinking about this scenario. So again, we're talking about an 18-year-old adult. So we're using the principles under the Mental Capacity Act. Parental responsibility doesn't apply, and Gillick competence obviously doesn't apply as the person's over 16. I'm talking about an 18-year-old adult. So again, you assess capacity yourself. This part, number 2, is really important and often overlooked, but the Mental Capacity Act states in the codes of practice that we need to consider whether the client has a lasting power of attorney or a deputy who's been appointed to make decisions about that person's health and welfare. Or do they have a valid advance decision, also called advance directive, which is specific to make this decision. And a lasting power of attorney or deputy and advance decision are all things with legal standings. So if there is a valid lasting power of attorney for health decisions, if there's a valid deputy or a valid advance decision, then we must respect that to make sure we are acting lawfully within the confines of the Mental Capacity Act. Now, of course, when it comes to a valid advance decision specific to make this decision, it's highly unlikely somebody has this. In this case, we're talking about somebody with a severe learning disability. So to be able to even make an advance decision in the first place, somebody has to have capacity. So of course, this person is not going to have a valid advance decision. And also it's very unlikely that anyone else would have a valid advance decision specific to making a decision about a forensic medical examination. Nevertheless, the Mental Capacity Act says we need to have considered this. So we need to consider asking the care home, as they are people who should know whether the client has anyone like a lasting power of attorney or deputy who needs to be informed about health decisions. And the GP may be another source of information. So the GP should ideally know if there is a lasting power of attorney or deputy in place for that person regarding health decisions. And then if we use the Mental Capacity Act and the client lacks capacity, we are allowed to proceed if it is considered in the best interests of the client. But if you don't know the client very well and you've just met the client, for you to decide what's in the best interests of the client, you will need to consider the views of friends and family or other people close to the patient, carers, perhaps other professionals involved, and you have to decide if it is in the best interests to continue with a forensic medical examination. You cannot allow that decision to be made by the carer or the family and the friends, because you, as the healthcare practitioner, are the only person who fully understands what a forensic medical examination actually involves. And of course, we should consider the views of friends, family, carers, professionals, and you will need to decide who to ask, which may just be friends and family or may just be carers. But you need to make that decision about who you're going to ask for their opinion on this, but making it clear that family and friends or carers are not making the decision about whether to do a SARC medical or not. Because carers and family and friends know the client, they will give you some insight into whether they think this would be in their best interests or not, but they are not making the decision. You as the healthcare practitioner are. And of course, in complicated situations, not necessarily this one, but sometimes the situation is much more complex, and you may want to involve the trust legal team or a medico-legal advisor. And of course, you can always ask more experienced colleagues to assist you in deciding whether this is in the best interests or not. And in this situation, as the index of suspicion of sexual assault is high, given the information from the police officer and the witness accounts, you can justify it if you said this was in the best interests of the client. So again, if it is in the best interests of the client, you proceed as tolerated. If at any point the client becomes distressed and no longer cooperates with the examination, then that's the point you review whether it's still in the best interest to continue or not. And if that is the case, that they are too distressed and not able to continue, then the examination is terminated at that point. So it can just be a limited examination. You only proceed as tolerated. In this slide, I've just highlighted two very useful documents from the Faculty of Forensic and Legal Medicine, and I'll add those links to the description box. But if you work in the police stations, it's really important you read the first document at the top. That's consent from children and young people in police custody. And if you work in the SARCs, you must read the document at the bottom, consent from patients who have been seriously assaulted